Good morning, ladies and gentlemen. Welcome to Bexar County Court at Law Number 6 and the Bexar County Veterans Treatment Court. Today is our Zoom motion to revoke docket, September 15th, 2021. It is approximately 10:15 a.m. Cases on my docket include cause number 876-428, State of Texas versus Francisco Ortiz, represented by Mr. Christopher Alonso. Cause number 621-498, State of Texas versus Brianna Vela, represented by Mr. Eric Hernandez. Cause 646-107, State of Texas versus Ernest Vasquez, represented by Mr. Adrian Flores. Cause 650764, State of Texas versus Rosemarie Diaz, represented by Mr. Raymond Martinez. Cause number 652127, State of Texas versus Hugo Alvarado, represented by Ms. Itzel Martinez. Cause number 656968, State of Texas versus Myra Gonzalez, represented by Mr. Ruben Flores. Cause number 656814, State of Texas versus Nicholas Rios, represented by Mr. Fernando Trevino. Cause number 648384, State of Texas versus Carissa Navarro, represented by Mr. Robert Maurer. Cause number 629833, State of Texas versus David Martinez, represented by Mr. Robbie Barrera. Cause number 638535, State of Texas versus Raymond Morris, represented by Mr. Jamie Hunt. And representing the state in these matters will be Mr. Guillermo Flores and Ms. Megan Galloway. Representing the Bexar County CSCD will be Ms. Susan Gross, who I will swear at this time. Ms. Gross, please raise your right hand. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Okay, we're going to take up at this time State of Texas versus Nicholas Rios, 656814 with Mr. Fernando Trevino. Mr. Trevino and Mr. Rios, I'm looking at a document entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have both your signatures on it. In fact, Mr. Rios, is this your signature on this document, sir?
Yes, sir.
Thank you. And Mr. Trevino, as attorney for Mr. Rios, is this your signature on this document?
It is, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. Mr. Rios, is this your signature on this document also, sir?
Yes, sir.
Thank you. And Mr. Trevino, as attorney for Mr. Rios, is this also your signature on this document?
It is.
Thank you. This is a motion to enter adjudication of guilt and revoke community supervision. My understanding is this is uncontested. Is that correct, Mr. Trevino?
That's all.
Well, it is, but with an explanation.
Fair enough. Mr. Rios, in cause number 656814 on the motion to enter adjudication of guilt and revoke community supervision, how do you plead, sir?
True or not true?
Thank you, sir. Court accepts the plea of true with an explanation. Ms. Gross, would you please advise the court and the parties of the status of Mr. Rios' probation?
Judge, I think Mr. Fernando is asking the defendant whether he is pleading true or not true.
I'm sorry, let's go back to that. Mr. Trevino, go over to you.
Nick, are you pleading true to the allegation?
Yes.
Yes, he is, Judge.
The court accepts the plea of true with an explanation. No problem. Go ahead, Ms. Gross.
Yes, Judge. The defendant reported July 22nd, 2021, which was his first office visit. He did not report in the month of August. He's paid $130 towards his fees. He has a balance of $1,397 and he is delinquent $258. He has yet to obtain a Smart Start mobile device. He has one negative drug test. We have no proof of enrollment or completion of the DWI Education Victim Impact Panel or CATSNP program. The officer is recommending that his probation be revoked. He be placed on regular probation, that restitution be added in the amount of $1,374.94 to the city of San Antonio, that he obtain a Smart Start mobile device within 5 days, and that he enroll in all of his programs within 7 days. This is his first violation report, first motion to revoke. His criminal history includes a felony arrest for assault of a pregnant person, and then he has a night mag on a failed to stop and render aid, and of course, the instant offense.
Both those other cases have been dismissed.
Hey, Mr. Trevino, it doesn't appear that Mr. Rios has done anything. What has Mr. Rios done?
Well, Judge, let me back up a little bit. He was just placed on probation at the end of July. He he's
This
trying
said,
to
wait,
actually.
wait. This says June 24th, 2021. Does that sound right? Not July.
Correct,
I thought
June 24th.
I'm
Go
sorry. I
ahead.
thought I saw July.
I
I thought I
understand.
saw July. I'm
I
sorry.
understand. No problem.
So I mean, he still has plenty of time to comply with all his conditions, Judge. I don't know that the restitution amount was. Could you repeat that restitution amount to the city of San Antonio?
$1,374.94.
And is that for the property damage?
It's to the city of San Antonio, so I assume he assaulted a police car or something, and he's paying for the damages on the car.
Right. Okay. So, well, okay, if that's the amount, that's the amount. And we're fine with that. I thought it was higher, but I don't know where I got that figure from. But Judge, Mr. Rios has had the ignition interlock on his vehicle from the onset, from the date of the arrest, or shortly thereafter. And it's not that he doesn't want to comply in getting the Smart Start mobile. He's happy to do that. He just needs the order to get that done. And
All he has to do is show up.
all he has to do is show up to Smart Start.
Yes, sir.
Okay, well, we'll instruct him to do that. He's not trying to not comply with your probation, Judge. Maybe he's a little confused about what he has to do, and I told him the best thing to do is to contact your probation officer to clarify all the terms. He's very anxious and motivated to get these classes under his belt, and I just want you to give him a chance to stay on this deferred probation, Judge, and see how it goes. He will be enrolling. Actually, he just got a job. He had to pay $1,000 to get out of jail on this MTR that was filed, and as a result of that arrest, he had lost a job that he was already promised, but now he has another job, and he wants to comply, pay his monies, and do everything he's supposed to. He hadn't had anything wrong with his ignition interlock. No violations, negative UA, and he's doing good. He's sober, he's clean, and he just wants to, have a little bit more time to comply, and I'll get on him, Judge. I'll give him the right act on when he needs to get this done by.
Ms. Gross, I'm looking at all your documents. Is there any criminal history on Mr. Rios? I can't find it.
Yes, he has 2 prior arrests: felony assault of a pregnant person and failed to stop and render aid.
And both have been dismissed.
Thank you. All right, the elephant in the room. Why did not Mr. Rios get the Smart Start mobile device? This is not rocket science. You drive over, you make an appointment, you drive over there, they put it on. I understand. Mr. Trevino, what's going on with that?
I thought he had to get an order, and I was asking the court to give me an order to give to him, but I guess if he could just drive up there and do it, he'll be happy to do it, Judge.
No, he's instructed when he goes through orientation that he has 5 days to get the device. He's given a list of locations to go and get those devices, and that's it. He's just got to show up, so he has no excuse. He was instructed on how to obtain a device.
Well, Judge, he might have misunderstood, but he's willing to comply. He indicates that he's happy to do everything you want on probation, Judge.
And what was the original fine amount on this case, Ms. Grove?
$750, Your Honor.
And correct me if I'm wrong, has Mr. Rios completed any programs or any classes or done anything positive?
Well, he was trying to get the money together so he could get into those classes, because they cost, they have to pay a fee to get in, and his financial woes were exacerbated a little bit by his arrest, but he's back on track. He's got a job, and he also has a plan of attack in terms of getting all those fines paid. He recently inherited, well, actually, he will inherit a house at age 25, but his aunt, who is not the trustee, the test, what do you call it? Anyhow, she's handling the state of his grandma, and they're gonna refinance the house and get him the money that he needs to pay off the restitution, unless he's able to do it with his income that he's making right now.
State recommendation.
Your Honor, the state recommends that the defendant be continued on deferred adjudication, that he obtain his Smart Start mobile within 5 days of today's date, and that he be required to blow 6 times a day when he does obtain that device. We would also recommend weekly UAs and substantial compliance within 7 days.
Mr. Rios, in cause 656-814, the court accepts your plea of true with an explanation. I grant the state's motion to revoke your deferred adjudication probation. I adjudicate you guilty of the offense of driving while intoxicated, first offense. I sentence you to 6 months in the Bear County Jail, probated for 1 year, assess a $750 fine plus court costs, 48 hours community service, DWI education, DWI victim impact panel, weekly report in UA. Once he shows me 4 clean weekly UAs, Fernando, I'll put him back on monthly UAs, but I won't know he's done it. You gotta have your client call you, you call me, I'll confirm it, and we'll take him back to monthly. Community Alliance for Traffic Safety New Intervention Program. Want him registered for all these classes within 10 days of right now. Smart Start Mobile Home Interlock at 6 blows a day. I want him active on Smart Start within 10 days. If he shows me a clean 30-day period of time at 6 blows a day, I'll crank him down to 4. Once again, I will not know he has done that. He has to tell you, you have to tell me, I have to confirm it with probation. Ms. Gross, what did I miss?
Nothing, Judge, but one thing, you want weekly reporting and weekly UAs or just weekly UAs?
I'm sorry, weekly UA, excuse me.
And then also, being that he's going to be going through the orientation process again, they will reach out to you. Fernando, Pat's going to resend you an application and a data sheet. You and your client need to fill those out and send those back immediately so that we can get his application over to probation. Mr. Rios, you're going to be going through orientation again, where they're going to explain everything to you again and give you a lot of the same paperwork. Judge, I will contact Mr. Fonseca. I will have him increase his Smart Start blows today to 6. And so Mr. Rios, reach out to Mr. Fonseca after this hearing, and he will give you your new blow times, okay?
Yes, ma'am.
And hang on, and restitution to the city of San Antonio in the amount of $1,374.94 for, I'm guessing, a police car window. I don't know what it was for. That's all I got. Fernando, you got anything else?
Yeah, Judge, you did continue him on deferred, correct?
I'm sorry?
No,
You did continue him on deferred, right, Judge?
Not at all.
That's
Took it away in a heartbeat. He's lucky he's not on his way to jail.
Okay, Judge. Thank you.
When's the
And,
last time you saw somebody not get a Smart Start mobile for 2.5 months when he was ordered to do so? Never. Thank you.
Right, but he had the ignition interlock and he thought he was complying.
Yeah,
It's
well, he
just,
wasn't. Trust me. Go ahead, Susan.
Okay.
Mr. Rios, I'm sorry, I misspoke. You haven't gotten your device yet, so you need to go to orientation. They're going to give you all the paperwork and everything else. Now, because you're already on with Mr. Fonseca, you're going to be staying with him, okay? So make sure you go to that orientation, and Fernando, make sure you get that paperwork back to Pat, okay?
Okay, I'll be on the lookout for it.
All right, Mr. Rios, do you have any questions?
No,
No
ma'am.
questions for me.
All right, good luck to you.
Rios, one final question. I give you your analysis test today. You gonna be positive for marijuana or anything else colorful?
No, ma'am. No,
Good
no,
answer.
sir.
Good answer, sir. Fernando, he also gets credit for any monies paid or any programs completed, which I think is none, but we'll start him over and give him one more shot. Anybody got anything else they
All
want
right.
to add?
No, that's it, Judge. Thank you.
Good luck, Mr. Rios. Thank you, Mr. Trevino. Have
Thank
fun
you,
at the
sir.
doctor.
Your
Are we
Honor, can we
ready?
do the defendant with the interpreter, please? Next, the interpreter has some other courts.
Okay, so right now, as we speak, we have no interpreter. Is that correct?
No, we do.
Oh, we
She's
do have an
gonna go.
interpreter.
If we can do her next.
All right. This is cause
Pat,
number
while you're setting
87.
that up, would you place me in a breakout room with Brianna Vella?
Yes. Okay.
It's cause number 876-428, State of Texas versus Francisco Ortiz. represented by Mr. Chris Alonso. Mr. Ortiz and Mr. Alonso, I have two documents for you to advise me about your signature status on. The first one's entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. In fact, Mr. Ortiz, is this your signature on this document, sir?
Mr. Alonso?
Apologize, Your Honor, I was muted.
Yes,
Okay.
Your Honor.
Am I waiting for the interpreter?
Actually, he's gonna try to do it in English, Your Honor. He wants.
Mr. Ortiz, do you speak English, sir?
Yes, sir, I do.
All right, so you don't need a Spanish interpreter. Is that what you're telling me?
I do not, Your Honor.
All right,
Okay.
Mr. Alonso, do you agree?
I do agree, Your Honor. I just would maybe some difficult words, extensive vocabulary is a little limited, but he speaks fluent English, Your Honor.
All right, well, permission of the state and the defense, I'll be happy to go forward in English, and I would ask Mr. Ortiz if anything is said that you don't understand or a word comes in that you don't understand, please stop the proceedings, let us know, and I'll let Mr. Alonso explain it to you. Would that be okay, Mr. Ortiz?
Yes, Your Honor.
All right, great. So we're not going to use a Spanish interpreter, but if we need any Spanish interpreting, Mr. Alonso, I would ask you to do so.
Thank you, Your Honor.
So once again, this is cause 876-428, State of Texas versus Francisco Ortiz. The first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. In fact, Mr. Ortiz, is this your signature on this document, sir?
Yes, Your Honor.
Thank you. And Mr. Alonso, as attorney for Mr. Ortiz, is this also your signature on this document?
Yes, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication. The defendant has a limited right of appeal. Mr. Ortiz, is this your signature on this document also, sir?
Yes, Your Honor.
Thank you. And Mr. Alonso, as attorney for Mr. Ortiz, is this also your signature on this document?
Yes, Your Honor.
I also have a document in Spanish, which I guess is not necessary today. Would that be accurate, Mr. Alonso?
That is correct, Your Honor.
Okay. I'm looking at a motion to enter adjudication of guilt and revoke probation. And Mr. Alonso, my understanding is this is an uncontested motion to revoke probation. Is that accurate?
That is correct, Your Honor.
Okay, thank you. Mr. Ortiz and cause 876-428 on the motion to enter adjudication of guilt and revoke probation. How do you plead, sir?
True with explanation.
Fair enough, sir. Ms. Gross, would you please advise the court and the parties with the status of Mr. Ortiz probation?
Yes, Your Honor. Mr. Ortiz was placed on probation March 17th of 2004. He never reported. He never signed his conditions. He has a balance of $901 on his fees. He never did his 80 hours community service. He was never drug tested. We have no proof of completion of a TABC course. He has no criminal history. And the probation department is recommending that his probation be revoked.
And Mr. Alonso, what are you requesting, sir? This is an ancient case, it appears.
Yes, and exactly, Your Honor. It is an ancient case. As a subject, we spoke about this, Your Honor, at the last setting. We granted a continuance to try to get some stuff from archives. Unfortunately, the court was right as usual. Archives was non-existent. We were able to just get the order for the original orders, but we weren't able to get any of the police reports. We still affirm that, obviously, he was innocent and he was unfortunately a victim of ineffective assistance of counsel. We understand that the Padilla matter is somewhat far after this case, as is a 2004 and Padilla is 2011. The issue here, Your Honor, is we conferred with CIU. Unfortunately, because it's still open, CIU wasn't able to help us on trying to do a vacation. He was deported right after 2004. He's been in Mexico this entire time. He thought the state and immigration were two entities that were speaking to one another. So due to his deportation, he thought the case was completed. If the court, he can pay the money, and to try to satisfy the court, he can also complete a class if the court deems. We would plead with the court to understand he was deported subsequent to this offense. Just recently re-entered to the United States in 2019. He's a family man with 4 children, no criminal history whatsoever within the United States or Mexico.
State recommendation?
Your Honor, we recommend that the defendant receive a JSAT, Your Honor.
Okay, Mr. Ortiz, in cause 876-428, the court accepts your plea of true with an explanation. I grant the state's motion to revoke your deferred adjudication probation. I adjudicate you guilty of the offense of furnishing alcohol to a minor. I sentence you to 6 months in the Bexar County Jail, assess a $2,000 fine plus court costs, credit for time served, time and money to run concurrent. You're to report to the Bexar County Jail at 9 a.m. on Monday, 9/20/21. However, if you pay in full the $901 you owe the adult probation department, I will waive your jail sentence. Defense, is that acceptable to you?
That is, Your Honor.
And today is Wednesday, so we have today, tomorrow, and Friday to get this money paid. Is that going to be a problem?
No, Your Honor, we'll pay it.
Okay, so otherwise, he's ordered to report to the Bexar County Jail at 9 a.m. on Monday, 9/20/21. Anything further from the state or the defense on Mr. Ortiz?
No, Your Honor.
Once he reports, once he pays the money, I will not know that. So Mr.
Okay.
Ortiz, please make sure your attorney knows. Mr. Alonso, you got my cell number?
No, I don't, Your Honor.
210 USA Army. Don't dial 800. You get the real USA Army.
I don't want to call them. I just got out in
Exactly.
July, so I'm fine.
although we have a job for you, I'm sure somewhere.
No,
Anyway.
I got out in July. I did my time.
Oh, that's right. We talked about that. All right.
Yeah,
Thanks
yeah.
for your service. All
Thank
right. So
you.
as soon as you call me and let me know he's done that, I'll call Ms. Gross. She'll confirm it, and I will enter an order that waives his jail sentence. Judgment satisfied.
Yes, Your
Anything
Honor.
further from the state or the defense on Mr. Ortiz?
Just a
Judge-
question for Susan, Your Honor.
Yes, Mr. Alonso, he can pay that at 207 North Kamal, which is
207
the 4-story building right across the street from the jail, across
Okay.
the street from the parking lot. He'll go in
Okay.
the left side of the building,
Okay.
and they take cash, cashier's check, money orders, and sometimes credit cards.
Okay. Thanks. That's the only question I had. Thank you.
All
And-
right. Thank you,
and there's
Mr.
a-
Alonso. Good luck, Mr. Ortiz. Y'all are dismissed.
And there's a
Thank you.
$2 fee to make the payment, so he needs to take an extra $2.
Okay, we will. We'll take care of it. Thank you, Susan.
Thank you. You have a good day.
Thank you, Your Honor.
Okay, you bet. Y'all take care.
Thank you.
Mr. Hernandez, are we ready on Miss Vela?
Yes, Your Honor, and I just sent Mr. Flores the offer we would be taking. So we're ready.
I'm sorry, you just sent Mr. Flores the what now?
We had discussed a couple of options, so I just let him know which option we'd be taking, so we're
Oh,
ready to
okay.
proceed.
Well, you make sure that, and let's go on the record. This is cause 621-498, State of Texas versus Brianna Vela. And Mr. Hernandez represents Ms. Vela, and apparently he has entered into tentative agreements with the state. Is that correct, Mr. Hernandez?
That is correct, Your Honor.
Okay, and I want to make clear to Ms. Vela and Mr. Hernandez and the state that I'm not bound by any agreement you may have made with the state, even if they entered into an agreement with you and promised to do something. Do you understand that?
Yes,
I do,
sir.
Your Honor, and I explained the same to Ms. Villa.
All right, fair enough. This is cause 621-498, State of Texas versus Ms. Brianna Vela. And this is a second amended motion to revoke community supervision. Representing Ms. Vela is Mr. Eric Hernandez. Previously referenced, representing in all these cases, Bexar County Criminal District Attorney's Office, Assistant Criminal District Attorney Guillermo Flores and Megan Galloway, and representing the Bexar County CSCD, Ms. Susan Gross, who I remind is still under oath. So that being said, Ms. Vela and Mr. Hernandez, I have two documents for you to identify your signatures on. The first entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. In fact, Ms. Vela, is this your signature on this document, ma'am?
Yes, sir.
Thank you. And Mr. Hernandez, as attorney for Ms. Vela, is this your signature on this document?
It is, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Ms. Vela, is this also your signature on this document, ma'am?
Yes, sir.
And Mr. Hernandez, as attorney for Ms. Vela, is this also your signature on this document?
It is, Your Honor.
This is a second amended motion to revoke community supervision. Mr. Hernandez, my understanding is this is an uncontested motion to revoke community supervision. Is that accurate?
It's accurate, Your Honor.
Thank you. Ms. Vela, in cause 621-498 on the second amended motion to revoke community supervision, how do you plead, ma'am?
What? Guilt?
Are the allegations true or not true, Ms. Villa?
True.
Court accepts the plea of true with an explanation. Ms. Gross, would you please advise the court and the parties of the status of Ms. Vela's probation?
Yes, Your Honor. Ms. Vela has been reporting as directed. We last saw her on August 4th of 2021. She has not made any payments towards her fees. She has a balance of $1,240 and is delinquent $254. We have no proof of completion of any of her 48 hours of community service, no proof of enrollment or completion of DWI Education Victim Impact Panel or the CATSNP program. She failed to submit to drug testing on one occasion. She had one occasion where she tested and it was diluted. She is currently on Smart Start Mobile testing 4 times per day. She's had 4 skip tests and 3 high BRACs. On one day, it was 0.046. A second instance was 0.078. And the third instance was 0.028. This is her first violation report, first MTR. Her criminal history includes arrests for fail to stop and give information, theft 100 to 750, this instant offense, and then she has an assault bodily injury pending in a misdemeanor court, but this offense occurred prior to her being placed on probation. Her original fine was $500. And her officer is recommending that her Smart Start be increased to 6 times a day. She submit to weekly drug testing and that she be placed on 0 tolerance for the term of her probation.
And I'm looking at the notes from the probation department. She has completed the Victim Impact Panel and the DWI education course, correct?
Yes, sir.
Is there anything else she's completed that I'm unaware of? Those are the 2 things I know for a fact she's completed.
Your Honor, in my conversation with Guillermo, I believe she had registered for CATSNP. I don't know if she began attendance or not, but she has not completed that program.
Ms. Vela, have you started doing any classes at the Community Alliance for Traffic Safety for the outpatient drug CATSNP course?
No, sir. I had turned myself in.
Okay, I got you. Okay, defense, what are you requesting?
Your Honor, Mr. Flores had made a recommendation to serve time. I've spoken with Ms. Vela and she's asking to be revoked and to serve her time out. She feels that's the most efficient way to get this resolved. She is still on bond for the County Court 13 case and planning to take that to trial. So even if she were released upon completion of that sentence, she will still be under some measure of supervision through pretrial services. So that's her request to be revoked. She feels that that's the best option for her at this time and would ask the court to give some deference to the fact that she did do the DWI education and the victim impact panel.
Defense, how much time in the Bexar County Jail do you think would get Ms. Vela's attention without over punishing her?
The state was going to recommend 21 days, so we would ask the court to consider 21 days. I called the court this morning. The clerks in the back confirmed that she has 17 days in Bexar County Jail at this time.
That's what my records reflect. State recommendation on Ms. Vela, please.
Judge, I agree with Mr. Hernandez's recommendation, given the totality of the circumstances.
Just for the record, Mr. Hernandez and Ms. Vela, I was in looking over these notes last night, I was going to offer you the ability to stay on probation if she would volunteer for the Scram bracelet, but that's $350 a month. So if y'all need to go chat about that, I'll leave her on probation and put her on Scram for probably a minimum of 60 days because I can't stop her from drinking. Now, if you guys know that the Scram is not going to really make a difference in the overall spectrum of the world and would rather take the revocation, that's okay too. That's your choice. Do you want to talk about that with your client, Mr. Hernandez?
I'd be glad to, Your Honor, but I've already had that conversation with Ms. Vela, and I think financials would be a hardship that she would not be able to overcome. She has not made any payments yet to the fines or court costs. So
okay,
adding additional financial hardship, I don't know that that would be in her best interest at this time. Correct me if I'm wrong, Ms. Vela.
Oh, no, you're right, sir. That's correct.
Judge, also for the record, the state, I either agree with Mr. Hernandez's recommendation or even perhaps adjacent, Judge.
and Susan, what was the original fine in this case, if you know?
$500, Your Honor.
And let me back up. Mr. Hernandez, is Miss Vela married, have children, working, going to school? What's going on in her life situation other than drinking on my probation?
I know she has one child, Your Honor. Regarding school or current employment status, I would have to defer to the defendant to answer those questions.
I also go to barber school. I sent it to my probation officer, Pat Benavides.
No comment.
No comment.
Okay, pursuant to your request, Ms. Vela, on clause 621498, the court accepts your plea of true. I grant the state's motion to revoke your probation. I sentence you to 60 days in the Bear County Jail, a $500 fine, plus court costs, credit for time served, time and money to run concurrent. She's going to be very, very close to time served on that anyway, so that's the best I can do. Anything further from the state or the defense on Ms. Vela?
No,
No,
Your
Your
Honor.
Honor.
From the-
All
from
right,
the
good luck, Ms.
defense, and
Vela.
I-
Thank you, Mr. Hernandez.
Thank you.
Judge. Have a good day.
You bet. Are we ready on Mr. Vasquez, Mr. Flores? Is Adrian with us? Yo, Adrian, I've always wanted to say that. Did we lose Adrian?
He had another hearing in court 8.
No
So
problem.
it's gonna
All
jump in and out.
We've got Mr. Martinez. Do we have Ms. Cruz here also?
Yes,
Yes,
they're
Okay.
here.
So we've got Ray Martinez, Victoria Cruz on Rosemary Diaz. Are y'all ready to proceed?
we are, Your Honor.
Clause 650764, State of Texas versus Rosemary Diaz, represented by Ms. Victoria Cruz and Mr. Raymond Martinez. As previously referenced, representing the state, Assistant Criminal District Attorneys Guillermo Flores and Megan Galloway, representing the Bear County CSED, Ms. Susan Gross, who has been previously sworn. I have 2 documents for Ms. Diaz and the attorneys to identify their signatures on for me. In clause 650764, Ms. Diaz, I have a document entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. Is this your signature on this document, ma'am?
You're muted, Ms. Diaz.
Yes, Your Honor.
Thank you. And it appears, Mr. Martinez, is this your signature on this document?
It is, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has the right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Is this also your signature on this document, Ms. Diaz?
Yes, Your Honor.
And Mr. Martinez, the attorney for Ms. Diaz, is this also your signature on this document?
Yes, Your Honor.
Thank you. This is a motion to revoke community supervision. My understanding is this is uncontested. Is that accurate, Mr. Martinez?
It is, Your Honor.
Ms. Diaz, in clause 650764 on the motion to revoke community supervision, how do you plead, ma'am?
It's true, right, Ms. Diaz?
True.
True. Court accepts the plea of true with an explanation. Ms. Gross, would you please advise the court and the parties of the status of Ms. Diaz's probation, please?
Yes, Your Honor. Ms. Diaz has been reporting as directed. We last saw her on August 11th of 2021. We have no record of any payments being made. She has a balance of $1,240 and is delinquent $254. She has not completed any of her 48 hours community service, and we have no proof of enrollment or completion of DWI education, victim impact panel, or the CATSNP program. She has submitted 3 drug tests, 2 were diluted, and 1 was positive for marijuana. This is her first violation report, first MTR. She has no criminal history. She's currently testing on Smart Start at 4 times a day. She's had 4 skip tests, and her officer is requesting that her Smart Start mobile be increased to 6 times per day for 60 days, and that she enroll in programs within 7 days.
Okay, Mr. Martinez.
Judge.
It appears we're not missing very many tests. Anyway, what is it you recommend or recommending and requesting with regard to Ms. Diaz's probation?
Judge, we just ask you to continue her the way she is. What happened with her Smart Start mobile, Judge, is she missed a test and she realized it. started looking for her device and realized she had misplaced it. So she missed a couple of tests one day and then realized she might have dropped it in the store she was in the day before. She called the Ross and in fact, they said, yes, we do have it. It must have fallen out of her purse. She went right back and got it and started testing again. My understanding is she's had no positives on the Smart Start mobile, Judge. And it was just due, because the store closed before she could get there that night, she had to wait till the next morning to go pick it up. So she's only been on probation since July 15th, Judge. So I understand she hasn't completed her programs, but she's probably just getting started on almost most of those things.
Ms. Diaz, I've got notes from the probation department that your probation officer says that she thinks you have a criminal attitude. I've only been doing this about 40 years, but I've never seen that before. That's kind of a, you have a criminal attitude, ma'am?
I do not, Your Honor.
All right.
I do not.
State recommendation about Ms. Diaz and her criminal attitude.
Your Honor, the state recommends that the defendant be continued on probation, that she be required to blow 6 times per day until she shows 30 days without missing any blows or any high bracs, weekly UAs, and substantial compliance within 7 days.
Okay, Ms. Diaz, in clause 650-764, the court accepts your plea of true to all allegations with an explanation. I deny the state's motion to revoke your probation or you continued on probation with all prior requirements and no sanction at this time, although I have the authority to put you in jail for 30 days to get your attention. Will that be necessary, ma'am?
Not at all, sir.
Good answer, ma'am. Altering amending conditions, modifying your Smart Start mobile device from 4 blows a day to 6 blows a day within 24 hours. If you show me a clean 30-day period of time at 6 blows a day without missing any blows and no high bracs for alcohol, I will crank you back down to 4 blows a day. But I will not know if you've done that. So you have to let your attorneys know. They'll let me know. I'll confirm it with probation. And I just send in the order and we crank you back down to 4 blows a day. I want to put you on weekly UAs. Show me 4 clean weekly UAs with no drugs or alcohol, and I'll put you back on monthly UAs. Once again, I will not know you've done that. You've got to let your attorneys know. They'll let me know. I'll confirm it and or send in that order. Substantial compliance in all other areas. Any programs you have not registered for, catnip, I think you're probably registered for. You just haven't started yet. You need to be at least registered on anything you're supposed to be doing within 10 days from today. Okay.
I have started my CAPSNIP and I comply with the drug and alcohol intake already. I have my paperwork, but I haven't been able to see my probation officer in person to submit those paperworks.
Okay, well, you're doing good. Just you can't miss any more blows. And
Yes, sir.
be sure to stay in touch with your attorneys. And once you've shown me 30 clean days on this 6 blows a day, let your attorneys know and we'll crank you back down to 4. Show me 4 clean UAs with no heroin or anything colorful in there. And
Not at all.
That was a joke, ma'am. That was a joke. And we'll get you back on monthly UAs. Anything further? State, I didn't ask for your recommendation, did I? I'm sorry. Go ahead.
You did, Judge.
All right. Anything further from the state or the defense on Ms. Diaz?
No, Your Honor.
Nope.
Nothing
Good luck,
from
Ms.
us.
Diaz. Thank you, Mr. Martinez. Thank you, Ms. Cruz. Y'all are out of here.
Don't go anywhere. Don't go anywhere. Ms. Diaz.
Yes, ma'am.
You will be receiving an email from either myself or Mr. Fonseca today with your amended conditions, okay? You need to watch for those, check for them, probably starting about noon, check about every 30 minutes, get that paperwork signed and send it back. The reason is I'm gonna be out of the office the next 2 days, so if this doesn't get taken care of today, okay, it's very important. And then Mr. Fonseca will be sending you an email or calling you with regards to your new times on your Smart Start mobile, okay?
Yes, ma'am.
All right, any questions?
Yes, ma'am. I have on this case, I have somebody that I have to report to. Do I still report to him
Yes.
by
yes.
phone?
No, that was
Um,
the pre-trial. That was pre-trial.
Oh, okay. All the pretrial stuff is gonna go away, but you're still gonna have Mr. Fonseca that you're gonna report to on a monthly basis.
Yes, ma'am.
And probably later today or early tomorrow, all your pretrial stuff will go away. Is that correct, Your Honor?
Yep.
Okay.
Only if you have any questions, Ms. Diaz.
All right. Good luck to you, Ms. Diaz.
Thank you, ma'am.
Okay, we got Mr. Flores back.
Yes.
Are y'all ready to proceed on Mr. Vasquez?
Yes, Judge. Apologize. I had a county court aid setting. I had to attend to.
Not a problem at all. We're gonna take a 2-minute break so I can refill my water. I'll be back. Stand by.
Thank you, Judge.
Yes, ma'am. Okay.
Okay, back on the record on call 646-107, State of Texas versus Ernest Vasquez, represented by Mr. Adrian Flores. And the first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. In fact, Mr. Vasquez, is this your signature on this document, sir?
Yes, it is.
Thank you. And Mr. Flores, as attorney for Mr. Vasquez, is also your signature on this document, sir?
Yes, Your Honor.
Thank you.
Yes, Your Honor.
Thank you. Next document I'm looking at is entitled Trial Court Certification of Defendant's Right of Appeal. I'm getting kickback here from somewhere. And is this also your signature on this document, Mr. Vasquez?
Yes, it is, Your Honor.
And Mr. Flores, as attorney for Mr. Vasquez, is this also your signature on this document?
Yes, Your Honor.
This document is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Okay, Mr. Flores, my understanding is this is an uncontested motion to revoke community supervision. Is that accurate?
That is accurate, Judge.
Okay. Mr. Vasquez, in cause 646-107 on the motion to revoke community supervision, how do you plead, sir?
True with the explanation.
Fair enough. What's the status of Mr. Vasquez probation in cause 646-107?
Yes, Your Honor. Mr. Vasquez has been reporting as directed. He last reported on July 22nd of 2021. He has missed 1 month of probation. He was only placed on probation May 20th of this year. He's paid $363 towards his fees. He has a balance of $783, and he is current at this time. We have no proof of completion of any of his 36 hours of community service, his DWI education program. He has completed the victim impact panel, and he enrolled today for CAT-SNP. He has 3 negative drug tests. He's currently on Smart Start Mobile testing 6 times per day. During the time period of May 20th to August 19th, he had 22 skip tests, and he has been in lockout since August 23rd of 2021. His criminal history includes arrests for possession of marijuana, 0 to 2 ounces, DWI, and of course, the instant offense. This is a first violation report, first MTR. His officers recommending that his Smart Start Mobile be increased to 8 times per day, and that the defendant shows substantial compliance within 30 days.
Okay, Mr. Flores, we're not going to 8 times a day. Our options here are scram or revocation. I'm just running out of options with Mr. Vasquez. What is it you're requesting, and what do you recommend?
Judge, we'd be we'd be requested to be continued. Judge, the reason he's on lockout, if you recall, he was in custody for a few weeks. He was released with COVID from the jail. He'd been unable to work for the first few days that he was released. Because he was released through COVID. He did not have any money to get out of lockout on his mobile device, Judge. He is now sufficiently quarantined from his COVID for being released from custody, and he's working again, Judge. And I spoke with them about getting the Smart Start reinitiated, Judge. So our request would be that he be continued on that. Understanding Your Honor's position, Judge, given that he is, again, actively employed, we'd given the position and the situation that Your Honor has put before us, we'd ask that he be, as opposed to being revoked, we'd ask that he be put on scram. Judge, one other thing, he was registered for the CATSNP and completing the CATSNP, but he got taken into custody before he was able to complete it, so he had to re-register it for it. And again, wait the mandatory quarantine after being released from custody with COVID to re-register for that, but he did register for that, Judge. So that would be our position on this, Judge. Again, that he be continued on Smart Start, and if Your Honor wants to increase him with substantial compliance, we'd request that. In the alternative, given the position that Your Honor gave us, we'd ask that he be allowed to be continued on probation with scram until Your Honor is satisfied with this progress on probation.
Susan, question, and Mr. Flores, you may have to throw in here. Are part of these skips because Mr. Vasquez was in jail, or these all skips during a normal time he was not in jail that he should have been blown in the machine?
Sorry, go ahead, Susan.
I looked at it, Your Honor, and they were when he was not in jail. He's been in lockout since October 23rd.
Okay, Mr. Flores, let's go back to my original question. My two options are he volunteers for scram, and you're telling me he can't afford scram. There's no really other ability I have to help him on that. I can't stop him from, I mean, I can't make him blow in the machine, it appears. So he's going to have a scram bracelet, or he's going to get revoked. So that being said, you're telling me he can't afford a scram bracelet. So my options are narrowing, if you grasp my gist.
Judge, as far as the scram, I know he's recently working again. He did have to rely on family support when he first got out. I'd like to, I guess, visit with them as far as his finances to be able to afford the scram bracelet.
I'm looking at scram. If he does scram well, we're only looking at 2 months of scram. If he does that well, then we'll put him back on the Smart Start. But obviously, everybody here knows I can't reliably trust him to blow in the Smart Start consistently in lockout. And I think that was based on his finances as you represented. So you guys want to go in a breakout room and chat about that? That's your two options. Either A,
yes, Judge,
he volunteers for scram and pays for it for at least 2 months. If he does well, it's only going to be 2 months. If he doesn't do well, it's going to be, until the end of probation for all I know. That's what we're looking at. Nate, you want to make your recommendation before he goes back in the chat?
Yes, Judge. The state recommends the scram device, register for the rest of the courses within 2 weeks, and show substantial compliance within 30 days.
Okay, so Pat, can you send them into a breakout room, and then when they come back, we'll finish up.
Of course, Your Honor.
Okay. Let me take a 1 minute break and I'll be right back. Okay, don't pay the ransom. I escaped. Ms. Martinez, are you ready to go forward on Mr. Alvarado's case?
Yes, Your Honor, but before we proceed, I would like to approach. I did confer with the state on this matter, Judge, and they are inclined to recommend a dismissal for this case. Now, I know that he does need a little bit more time to submit motions to that effect and to get approval from this court to that effect. And so I just like to address that before we begin, Judge.
In high-speed pass, I'm looking over Mr. Alvarado's case 652127. My understanding in reviewing the documents provided by both sides are that he has completed the 24 hours of community service that was an original allegation, and he's already completed or is in the process of attending the Community Alliance for Traffic Safety New Intervention Program. I think he's already done it.
Yes, Your Honor, he has already completed all the classes associated.
And therefore, that's just one instance of drinking where, if correct, he blew a .040 on or about May 16th, 2021, and there have been no further problems since then. State, is that your understanding of the facts on this case?
That's my understanding, Your Honor. And also, according to Ms. Martinez, the defendant also completed all hours of community service and he paid the fees and fines. So if that's the case,
Miss Martinez needs to be a judge. She can get these guys to do more stuff than I can. I don't know how you're doing that. All right, here's what I suggest. State, you can move to withdraw the MTR, and we'll just do it orally on the record at this time, and I'll certainly grant it. Ms. Martinez, what I would do with Mr. Alvarado is increase his Smart Start mobile blows from 4 times a day to 6 times a day, with the understanding, once he showed me a 30-day period of time with no missed tests and no high blows for alcohol, I'll crank him back down to 4. That's all I would do to him. He's doing well in all other areas.
And that's for 30 days, Judge?
Yeah, but I won't know he's done it. If he does that, he's got to tell you, you got to tell me, and I'll confirm it with the probation department.
Yes, Your Honor.
Is that okay with you, Mr. Alvarado?
Yes, sir.
All right. State, you want to go ahead and make your motion?
yes, Judge, if that's the case, the state moves to withdraw the MTR on 652-127.
And no objection from the defense. I will grant that. State, you need to go ahead and do I think you do a written motion, and I'll grant it, but as a matter of record, it's granted right now. So this motion is withdrawn. There's no pending MTR. I'll send in an order to withdraw any pretrial motion stuff I may have done. I don't know what perhaps conditions I put on a pretrial bond, but those are going to be withdrawn as of today. Anything further from the state or the defense on Mr. Alvarado?
Yes, lowly probation has something.
Sure.
I will take care of the motion to withdraw order and get that submitted to you when we do our paperwork at noonish. And Mr. Alvarado, you will be receiving amended conditions from your officer through your cell phone on your email. You need to sign those and return those back to her. And she will be increasing your blows from 4 to 6 times per day. And she will reach out to you and let you know what those new times will be. She's not going to know about any of this because I have to be the one to tell her. And I'm obviously here for the morning. So you may not hear from her till late this afternoon or tomorrow. Okay.
Yes, ma'am.
All right. You have any questions?
No, ma'am.
All right. Good luck to you.
Good luck, Mr. Alvarado. Thank you.
Your Honor.
So y'all are out of here. Go ahead.
I had also submitted a motion to modify conditions of release. It looks like Mr. Alvarado is paying on both the Intoxilock and the Smart Start. We would just respectfully request that he be put on one or the other, preferably the Smart Start. So if we could get a removal of the Intoxilock as well, Judge.
Sure. That's absolutely correct. And in the future, if you got anybody, all we use is Smart Start mobile devices. So any other, except for Scram, if that becomes necessary. Every other device we don't use. So they certainly, once they're active on a Smart Start, they can turn in their old device, whatever it is.
No objection from the state, Judge.
All right, great, thanks.
All right, and Judge, I'll submit that paperwork to you at noon as well. And that probably won't get to the court and to the officer until sometime tomorrow. So touch base with your officer tomorrow and they can let you know when they've sent it so you can go in and get that removed from your car. But it definitely won't happen today, okay?
Okay, thank you, ma'am.
All right.
Okay, y'all are out of here. Thank you.
Thank you, Judge.
Back on the record on class 646-107, State of Texas versus Ernest Vasquez. Mr. Flores and Mr. Vasquez have returned to the hearing from a conference. And Mr. Flores, what did y'all determine you wanted to do?
Judge, he paid his Smart Start. He's out of lockout. I don't know if that changes the schematic for your honor about pushing him up to 8 months.
Smart Start only works if you blow into it, and I can't make him blow into it. That's our problem.
Understood, Judge. Understood. So because you paid the Smart Start fee, Judge, he gets another paycheck from his job tonight that he can pay to get the Scram. He wants to do Scram. If he can have 24 hours to get that installed, he does have his Smart Start at this moment.
I'm gonna give him 5 days to get on Scram. Will that be enough time? I mean, depends on what the Scram people tell us as far as having the units available and whatnot, but
That'll be enough, Judge.
okay. All right, Mr. Vasquez, I don't want to set you up for failure. You've been telling us you have all these financial problems. I'm sorry it's that way. Do you have a job at this time, Mr. Vasquez?
Yes, my job that I've had for 2 years. Yeah, I work full time. When I went to jail, I almost lost my job, but thankfully my boss let me keep my job, so I'm still employed. The financial issues is because I was in jail. This is my first paycheck I'm getting from my job tonight. And I just paid my Smart Start Mobile today to get it out of lockout. I re-registered for CatSnip. I've done the victim impact panel class as well. And I was going to start my community service next week on my day off because the place is only Monday through Friday from 9 to 5 when I can do it.
Okay.
And then I just need to get into my DDBI intervention class, which I'm just waiting for my other paycheck so I can afford to get into that class as well.
Okay. Mr. Flores, you might need to get involved in this, but Mr. Vasquez, when you're talking to the Smart Start people, you don't need to reactivate your device, so to speak, because I'm putting you on this different device. You need to let this device go. So I don't know if that's less money, you know, if you just tell them you're turning in the device and you're not reactivating it because the court has ordered you to go on a Scram cam for a month or two before we get this figured out. And then we're going to put it back on back on Smart Start, and then let you take the Scram off. So I don't know how they, Adrian, I don't know how that works with regard to the monies from Smart Start, but you might want to ask them or make a call to smooth the waters there for Mr. Vasquez to get that done. I don't want him paying for like another month of Smart Start if he doesn't have to. It's kind of where we're at.
I'll coordinate that with them, Judge.
Judge,
All right. Yeah.
he would have had to pay the device up to current in order to remove it anyway.
All right.
So, and Mr. Vasquez, well, go ahead and do your thing, Judge, and then I'll give him his instructions.
All right. Mr. Vasquez, and state, did I get your recommendation on Mr. Vasquez's case?
Yes, Your Honor.
Okay. Mr. Vasquez, in cause 646-107. Court accepts your plea of true. I deny the state's motion to revoke your probation or to continue on probation with all prior requirements with no sanction at this time. Altering and amending conditions, ordering a Scram cam ankle bracelet, alcohol detecting device to be installed within 5 days. If there's a problem on that, get with your attorney, he'll get with me. Sometimes the company runs out of devices and whatnot, and it's out of our control. And in the meantime, as soon as your other device is not active anyway, but if it were, you would be able to turn it in as soon as the Scram is active.
It is active, Judge. He paid for it this morning.
Oh, he did. All right. Well, then stay on the Smart Start till you get the Scram active, and then you turn in the Smart Start. And let's see, Susan, what else do we need to do? Will that take care of it?
Yes, Judge. And how long will he be on the Scram device?
At least 60 days.
Okay.
You can check with me after 30, Mr. Flores. On rare occasions, I might let you know if he's squeaky clean, the possibility exists. We'll take him off of the Scram device in 30 days and put him back on a Smart Start. But it'd have to be really squeaky clean, and he's doing lots of good things for us.
I will. I promise I will, Judge.
All right, you're the man, Mr. Vasquez. Ball's in your court. Anything further from the state of the defense on Mr. Vasquez?
No, Your Honor.
Good luck, Mr. Vasquez. Thank you, Mr. Flores.
Mr. Vasquez, you'll be
Yes,
getting
ma'am.
an email from your officer with your amended conditions, probably later today. You need to sign those and send those back. She will also give you the referral so you can go get the Scram. If you don't get it today, then you'll get it tomorrow. Once you're active on your Scram device, you can let her know and she will send in a request to take off the Smart Start device. Okay, then the judge will sign that and then it'll go back to her. She'll send it to Smart Start. Then you can go turn in your device. But you need to blow into your Smart Start until you have that device strapped around your ankle.
Okay, and this morning when I paid to get it turned back on, I still have to pay. I still owe $118 to be current.
Okay, you're probably gonna have to pay that before they'll take it off, just so you know.
Okay. Okay.
So, get your lawyer involved in that if you need to, and maybe he can get it fixed where you don't have to pay another month on that thing. Okay? That's
Okay,
between
thank
you and Smart Start and your attorney. All right, good luck, sir.
Thank you.
Are we ready on cause number 656-968, State of Texas versus Myra Alexandra Gonzalez?
Your Honor, the attorney has not shown it, nor has he signed the paperwork or his claim.
So have we heard from Mr. Flores?
Supposedly, they told me that it would be 15 minutes, and that was about 15 minutes ago. He
All right.
had some hearing.
Are we ready on cause 648-384, State of Texas versus Carissa Navarro? Mr. Maurer.
Judge, I actually need to talk to Susan first. This case just got filed last week. She's got a warrant for arrest. You remanded her, so we set it for a hearing, but I need to talk to Susan. It's alleging 2 UAs, and I need to find out more about how the UAs were done and whether or not we can still submit for confirmation. And I had my client do a hair follicle test.
Well, let's just all chill out for a minute, and then that's still on the record, obviously, but not in the actual hearing. In cause 648-384, State of Texas versus Carissa Navarro. When I was going over this last night, I see that she's got a criminal mischief case, and she was on probation August 5th, 2021. So that's what, a month ago, probably, plus or minus. She's got 2 positives for marijuana, both of which occur within 30 days of her being placed on probation. And I have a policy. I'm sorry?
She has 3, Your Honor.
3 positives for marijuana, but they're all within 30 days of her being placed on probation, correct?
No, Judge, we actually had a hearing last week on an MTR. You continue to put her in an IOP. And so I've talked to my client that we thought this issue was in regard to some surgery she had and some medication, but that's not the case. But she's adamant she's not smoking. I had her submit to a hair follicle test, but I won't get the result till tomorrow.
Here's the point I'm trying to make, Mr. Maurer. I give everybody kind of a free 30 days when they come on probation for marijuana, because obviously they could have smoked marijuana before they came on probation, and it's going to stay in your system for plus or minus 30 days after you smoked it. So the 31st day after on probation, then they're in my killing zone if they're smoking marijuana. But in the meantime, if they come up positive during the first 30 days of probation, I don't hold it against them. This MTR got by me in some capacity. I missed the dates or something, or I would have said something back then.
And Judge, she's adamant she hasn't been smoking. That's part of the issue. And she is, I think you revoked her deferred and put her on regular. Isn't that correct, Susan?
Yes, Judge, we were here on August the 5th of 2021, and she was revoked at that time. And the reason for revocation is because she had positive drug tests, not only for marijuana, but also for cocaine. And you gave her a chance, and the smoking is continued because her levels have gone from 442 to 711 to 294. And so, she's continuing to smoke somewhere. She may have quit now because her last drug test was, I believe, on August 27th, and that one was still positive.
And I, of course, dispute all those allegations, which is why I wanted to talk to Susan to find out. I don't think they're doing these, and that's what I talked to Susan about. I'm not sure. Are they still doing the UAs at probation, or are they sent to a separate facility to do them?
They're going to recovery healthcare.
Okay. So I obviously, Judge, if I'm going to get, my client's going to plead not true, and I'm going to request a contested hearing, and I'd like to find out what the protocols are at the recovery healthcare. I'm sure they are not as meticulous as the good people at Bexar County Probation.
I've got a good idea.
It's the same people.
Everybody stop talking, please. Is Miss Navarro present today? I don't see her on screen anywhere.
No, I just talked to her. She may still be in the breakout room.
Your Honor, she may be in the breakout room.
Okay. Why don't you go talk to, everybody stop talking, please. Mr. Maurer, please go talk to your client and tell her I'm going to send her out for UA today.
Okay.
And if she's positive for something, then we'll talk again. If she's negative, I'm going to request the state withdraw this MTR and we'll move along, and she'd be on regular probation. That sound fair?
It sounds eminently fair, wise, beyond a saint.
Anybody's predictions, right, Mr. Barrera? Yeah.
Ms. Maurer, you can go back to where you were.
State, would that be okay with you? We're gonna have a gambling game here. What we're gonna do is the state's betting she's gonna come up positive for marijuana, and the defense.
I've got $10 on that, Judge, against Mauer. I got $10.
Well, just, you and Bobby, because you know Bobby's positive.
Bobby's been positive for something. Too much fun. He's positive for too much fun for the last
Where
40
do I
years.
send, Judge, Susan, do I send him to probation, Judge, or where do I send her?
Susan, over to you.
She's gonna be going to the recovery healthcare,
Okay,
and she can call her officer prior to going over there.
okay,
And because the officer may need to put the UA into the computer. Just,
okay.
have her call her officer and say, I was in court, judge ordered me to do a UA today. Can you put it in the computer? And then she can go over there.
Hey, Judge, you want us to log back on tomorrow? Will it get done today, Susan?
Just contact, I'll just see what the outcome is. The
Okay.
bottom line is it's up to the state where they want to withdraw this MTR or not. I can't order them to do that, but I can deny it if it comes up negative.
Okay.
You know, we all want it to be negative, but Susan, go ahead.
Can we just reset it for same time, same place next Thursday?
Sure.
And we should have the results back then, and we can resolve that at this time
Sure.
or at that time.
And Mr. Mauer, tell her not to drink anything. I don't want a diluted test today.
I will tell her. I may go drink something, but
If we get a diluted test today, then I'm gonna ask the state to amend the MTR and add the dilute.
I understand completely. I guess I'll go back to the same breakout room. I'll go chat with her. I'll tell her to log off.
Okay, thank you.
Thank you.
Bring my $10.
Okay, Mr. Brewer, are you ready to go forward on Mr. Martinez?
I'm ready to confer with Susan and or Mr. Flores or both of them, Judge, because I've got some issues on interpretation of this MTR.
Okay, Mr. Hunt, are you ready to go forward on Mr. Morris?
I am, Your Honor.
State, can one of you guys handle Mr. Barrera in the breakout room and the other one stay here and do Mr. Morris' case for me?
Yes, Judge, I can confer with Mr. Barrera.
All right, done.
I'm gonna put you in room 5, Mr. Barrera in room 5.
Thank you.
You're welcome.
Okay, this is cause 638-535, State of Texas versus Raymond Morris, represented by Jamie Hunt. First document I have for you guys to identify your signatures on is entitled Defendant's Consent to Motion to Revoke Hearings by Video Conference. Mr. Morris, is this your signature on this document, sir?
It is, Your Honor.
And I'm sorry, it's James Hunt. They didn't get the S on the end of it. Sorry, James. And Mr. Hunt, is this your signature on this document also, sir?
It is.
And the next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. Mr. Morris, is this your signature on this document, sir?
It is, Your Honor.
Thank you. And Mr. Hunt, is this also your signature as attorney for Mr. Morris?
Yes, Your Honor.
This is a sixth amended motion to enter adjudication of guilt and revoke community supervision. My understanding is this is uncontested. Mr. Hunt, is that an accurate analysis?
Yes, Your Honor.
Okay, Mr. Morris, in cause 638-535 on the sixth amended motion to enter adjudication of guilt and revoke community supervision, how do you plead, sir?
True.
Ms. Gross, would you please advise the court and the parties of the status of Mr. Morris' probation?
Yes, Your Honor. Mr. Morris has been reporting as directed, has paid $604 towards fees, has a balance of $429 and is current at this time. We have no proof of any of the 24 hours community service having been completed. There have been 3 negative drug tests, 1 failure to submit, and 1 positive UA for alcohol on the UA. And then also on Smart Start Mobile, he's been testing it 4 times per day. He's had 66 skip tests, and there have been 11 high bracs. The high bracs are from 0.038, 0.028, 0.020, 0.032, 0.024, 0.024, 0.032, and 0.021. He obtained his Smart Start 2 weeks after the court end date of which he was supposed to obtain the device. He's been in lockout since September 3rd of 2021. He's completed DWI education, victim impact panel, and we have no proof of completion of the CATSNP program. This is his first violation report, first MTR. He has no criminal history, and his officer is recommending substantial compliance within 30 days.
You told me he had 66 total skips and how many total positive BRACs?
11.
That could be a new world record.
Yes, and he's still in lockout, and he obtained his device 2 weeks after the court's deadline to obtain the device.
And what programs has he actually completed? I saw him having completed the victim impact panel after the MTR was filed. Does that sound right?
And the DWI education, but
And
no
the
CATSNP.
I got you. Mr. Hunt, what are you requesting?
Judge, I'd like to see him continued on probation, get back on track. If the court wants to increase his testing, we're certainly favorable with that. He's
not blowing in it. How good does that work?
Well, he has a great job. He's an electrician working to build a new Amazon warehouse. He's actually, I believe, fairly high up in the company, doing well in other aspects of his life. And once he gets back on track on this, I think he'll be doing well on this aspect too.
I can't stop him from drinking. That's my problem. I mean, look at all these. This is amazing. I mean, obviously he's got something going on with his alcohol deal, and the textbook solution is either jail or inpatient rehab. And the problem we're having with inpatient rehab, if I wanted him to go to SADA, which is our substance abuse treatment facility, minimum time is 120 days in SADA. And currently it takes, Susan, correct me if I'm wrong, it takes probably 60 days sitting in jail before you get to go to SADA for 120 days. Is that accurate, Susan?
Yes and no. Actually, I believe it's going to be a little bit longer than that.
So that's a big problem with getting the inpatient. But State, what's your recommendation on this one?
Your Honor, our recommendation is going to be that the defendant be continued on probation, that he be amended to blow into Smart Start Mobile 6 times per day, weekly UAs, and substantial compliance within 10 days.
Okay, State, he skipped 66 blows. I can't get him to blow in the machine, so that's not an option anymore. If he's not going to blow in the machine, having the machine at 100 blows a day doesn't help.
Well, Judge, since this is his first MTR, then in lieu of that, we would be recommending Scram.
All right, let's talk about Scram. Mr. Morris, or rather Mr. Hunt, is Mr. Morris willing to volunteer to pay $350 a month to be on a Scram bracelet to stay out of jail? Because that's kind of where we're at.
I am certain that he would.
Is that correct, Mr. Morris?
Would that be for a couple of months, Judge?
It would be for a minimum of 60 days. If he was squeaky clean after 60 days without any positives, I would be ecstatic, and I would let him go back to the blow-in machine, the Smart Start Mobile, if he's willing to blow into it. Our problem is, and Mr. Morris, you can feel free with your attorney's permission to comment on this, but I'm assuming you have an alcohol problem. I don't know to what level it is. I can't stop you from drinking, number one. And the reason you're not blowing in the machine is you don't want to show me you're drinking, number two. So that's my problem. The Scram bracelet is going to monitor you 24 hours a day. So I'll have a warm, fuzzy feeling. If you drink, we're going to find out about it. But you know right now, better than any of us, if you're going to be able to stop drinking or not. If you can't stop drinking, even though I've got this bracelet thing on you that costs a fortune, you know, you're just going to be right back here again. So that's our issue. Can you stop drinking, sir? That's the ultimate question. Can you stop drinking?
Yes, Your Honor, I can stop drinking.
All right, good answer. Mr. Hunt, you need to go chat with him about the Scram, or are y'all willing to go on Scram?
We are willing to go on Scram.
Fair enough. Mr. Morrison, clause 638-535. Court accepts your plea of true with an explanation. I grant the state's motion to revoke your deferred adjudication probation. I find you guilty of the offense of driving while intoxicated. I sentence you to 6 months in the Bexar County Jail, probated for 1 year. What was our original fine amount, Susan?
Ooh, 1 second here. I usually write that down, but I missed that one. It looks like Mr. Morris's original fine was $300.
And did you tell me, Mr. Morris, that you're currently registered for cat snip? You just have, that's our outpatient drug program. You just haven't started the classes yet. Is that correct?
That's correct.
Susan, do you see any benefit to being registered for cats IOP as opposed to regular cats at this time?
Given the extensive alcohol consumption in the short amount of time that he's been on probation, I would recommend that we forego cat snip and put him into CATS IOP because it is a much longer and more intensive program.
All right. Mr. Morrison, cause 638-535, the court having revoked your deferred adjudication probation, found you guilty of the offense of driving while intoxicated. First offense, I sentence you to 6 months in the Bear County Jail, probated for 1 year, a $500 fine plus court cost, 48 hours community service, DWI education, DWI victim impact panel, Community Alliance for Traffic Safety intensive outpatient program, Scram CAM ankle bracelet within 5 days of today. If there's a problem, sometimes they run out of units and whatnot. Let your attorney know, he'll let me know, and we'll deal with it. I'm gonna put you on weekly UAs till you show me 4 clean UAs. Show me 4 clean UAs in a row. I'll put you back on monthly UAs, and I won't know if you've done that. So if you do that and get 4 clean UAs in a row, let your attorney know, he'll let me know, and we'll put you back on regular monthly UAs. You're gonna get credit for any monies paid or any programs completed. Susan, what did I miss?
Judge, if I may, being that he's gonna have to go through intake again, you'll be receiving from Pat a new application and data sheet that needs to be filled out and sent back immediately today. And because he's gonna have to go through that process, Judge, I would ask that you give the defendant 10 days to obtain the Scram device because he's probably not even gonna get to orientation until next week.
Okay, not a problem. Scram within 10 days.
But I would suggest that he utilize his Smart Start mobile device in the meantime.
Is it active currently?
That I don't know.
Mr. Morris, is your Smart Start device working currently right now?
It is, Your Honor.
Okay. And are you on 4 blows a day, I'm guessing?
That is correct.
Keep blowing into it 4 blows a day.
Yes, sir.
And Mr. Morris, once you show proof that you're on Scram, your officer will send me an order. I'll send it to the judge. He'll sign it. Then it will go back to Smart Start. Then you will be able to stop blowing. So you're probably going to have a day of overlap where you're blowing and you have the ankle monitor. Okay.
Yes,
All right. Do you have any questions?
I do not.
All right. You're going to be going through orientation again. So be watching your email for an orientation date. If you do not get an orientation date by Friday at noon, you need to call intake at 210-335-7446. Okay. And
If I may say something, please be sure to fill out the data sheet completely. Just because you were on probation before, they need to update that data sheet. Thank you.
All right, Mr. Morris, I'm ordering what I call substantial compliance, meaning that if there are any programs you're not already registered for, you need to be registered for them within 10 days. You may not start doing those things, but you'll at least be registered and you know what's coming. And you can't see my notes from last night when I went over all these different cases, but my original notes said revoke. So the only reason you're not getting ready to report to jail on Monday morning is your attorney has saved you this time. It will not happen again. Do we understand each other, sir?
Yes.
In
Yes,
over
sir.
40 years of doing this, I've never seen anybody with 66 skips. That's incredible. So that being said, you've been warned. We want you to do good. You get to start over today. Your attorney has saved you. Mr. Hunt, fine job. I don't know how you did it because I don't, you know me and you know I normally put these kind of people in jail.
I'm
Judge,
aware.
All right.
Is he getting credit for all monies paid and programs already done?
Anything he's done or paid, he gets credit for. Absolutely. Any further questions, Mr. Morris?
No, sir.
Good luck. Do good. Thank you, Mr. Hunt. You are dismissed.
Thank you, Your Honor.
Mr. Barrera, you can go back to 5. Your client is in there.
Back on 629-833, State of Texas versus
you.
David Martinez. Mr. Barrera, what do you got?
I'm going to 5 to confer with him about some options that Mr. Flores and I have talked about as an alternative to what the court may consider.
Let me look at this real quick. Maybe we can cut to the chase here. All right. I missed this on the first pass. Is my understanding correct that Mr. Martinez had 10 skips on the Smart Start mobile device at 4 blows a day in 5 months?
That's what I am disputing, and I've just reviewed the court summary. And maybe we ought to bring him back in, Judge, so he can hear what we're talking about.
That'd be fine. That'd be fine.
You want him back in? I'll bring him in.
Yeah.
The point I'm making, Bobby, is if he only had made 2 skips a month, that's not a big deal. 10 skips in 5 months, that's 2 skips a month, right?
Well, and everything that he's been laid on, Judge, because he works construction, everything that he's been laid on has been clean. There are no negative tests. I mean, no positive tests.
Hey, hang on, Ms. Martinez, you're back with us. I don't know how you got inverted. Have you been drinking again? No, that was a joke, sir. You're kind of, I don't know how to fix that. Anyway, back on the record on 629-833, State of Texas versus David Martinez. Everybody stop talking for a minute while I get the cards on the table. My understanding and looking at the allegations against Mr. Martinez is the state alleged that he skipped 10 Smart Start mobile blows from March 31, 2021 to August 22, 2021, which is plus or minus 5 months. Does that sound right, Susan?
Yes, Your Honor.
So he only skipped 2 Smart Start mobile blows, averaging a month for 5 months?
Correct.
Because normally when y'all send these to me, that's like 10 blows in 30-day period of time. So I just missed that. So I'm not near as mad at Mr. Martinez as I would be if that was in 30-day period of time. State, I'm going to ask you to withdraw this MTR because I would not have signed it, and probably you wouldn't have signed it if we all figured out that he only missed 2 blows a month.
That's fine, Judge.
Make your motion, State.
Absolutely.
All right, granted. Mr. Barrera and Mr. Martinez, the state has moved to withdraw the motion to revoke community supervision, and I have granted it orally. They're gonna Susan back us up with a written motion, which we'll sign and date this date. Mr. Martinez, you're back on probation with all prior requirements, no sanctions, no nothing. Just continue doing what you're doing and don't miss any more skips or tests, okay?
Your Honor, thank you very much. May we still get in a breakout room so I can talk to him briefly, so make sure you
Y'all
understand.
can go back into 5.
Thank you so much. Appreciate it. Have a great day, y'all.
You too.
Good to see you, Bobby.
You as well.
See you.
Okay. Did we get Mr. Flores back?
Your Honor, Mr. Flores has not come. I'm about to call his office and find out what's going on, if that's okay with you.
Yeah, that'd be great. Ms. Gonzalez, I'm sorry for the wait. We're looking for your lawyer. We'll track him down.